Thank you.
Simple.
The next witness is Philip Dove.
Back to stand, please. Take the Bible and repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. Please
Thank you.
Thank you. Just take a seat.
Thank you. Can you give your full name to the inquiry, please?
Philip Charles Dove.
Mr. Dove, you have provided a statement to the inquiry. That's at CJS 0074040. I'm going to ask you some questions about various topics within that statement, but I'm not going to take you through it line by line because I'm going to ask that the entirety of it is adduced into evidence. You, I don't think, were employed by G4S Health Services as Managing Director during the relevant period, is that right?
That's correct.
What is your current job title?
Managing Director of Facilities Management and Public Services.
Are you also Director of G4S Health Services UK Limited?
I am a Director of G4S Health Services, but I also have a Managing Director running the business.
Thank you. What does that role entail?
My role,
Yes.
I run a number of disparate businesses, including health services for G4S.
You're the corporate witness that's been put forward by G4S Health Services to provide evidence to this inquiry, is that right?
That's correct.
You're here to answer questions on behalf of the company about the relevant period and about the current position, is that right?
That is correct.
You say at paragraph 2 of your statement, I have no personal knowledge as to any of the matters identified in the BBC Panorama programme. I also have no first-hand knowledge of the management of healthcare at Brook House between April and August 2017, or about the contractual / commissioning arrangements between the Home Office, G4S and NHS England during this time. Is that right?
That's correct. I didn't join G4S until November 2017 and had no responsibility whatsoever for the health services business until January 2019.
Yes. At paragraphs 30 and 101 of your statement, you say that you're unable to comment on lessons learned due to a lack of personal knowledge and a loss of staff. And a number of other times in your statement you refer to a loss or a lack of knowledge in the company, at paragraphs 22, 105, 107, 112 and 172 to explain why you've been unable to answer questions posed of you by the inquiry. In those circumstances, how well placed are you to provide the corporate evidence on behalf of G4S Health Services to this inquiry?
I think I'm the best current employee of G4S to provide the corporate statements. However, I would imagine that the statements you received from other people who used to work for G4S at the time will be more relevant to the period the relevant period.
Is G4S Health Services committed to learning lessons as an organisation?
G4S is always trying to learn lessons.
And is G4S Health Services committed to learning lessons from what was shown on the Panorama programme?
Yes, I believe it was, and continues to be so.
And committed to learning lessons from this inquiry?
Yes, where relevant.
Because, of course, the importance of learning lessons is to prevent past problems or failures occurring again in the future.
Indeed.
And in this case, that led to mistreatment of vulnerable detainees. So important to prevent those failures and problems occurring again.
Indeed.
Does your inability to comment in some of those respects suggest that G4S Health Services has, or at least had, no system in place to ensure that lessons learned were passed on from predecessors?
No, I think a considerable time has passed. It's 5 years since the relevant period. I think businesses evolve and change, and I think that I would hope that lessons were learned, and I believe they were, and I believe there was an intense period of reflection and action immediately after the Panorama programme. And as such, I believe that processes are in place to continue learning and to continue to develop.
A process is now in place to prevent the loss of company knowledge that you've referred to in your statement.
I think some of the questions here are so very specific to such very specific matters that it's difficult to say that you will not lose that knowledge because it's such a detailed question that's been asked. I think the general principles are understood and hopefully have been commented on.
What about systems of auditing and documentation?
I think that there were systems of auditing. I think that we constantly evolve auditing and documentation, and although there are some gaps that are talked about, I think there's a good quantity of documentation that is available and has been reviewed and submitted.
Paragraph 3 of your witness statement, you state that you've made the statement on the basis of information provided via inquiries and or of review of the company's documents and records. Have you spoken to people who were in post during the relevant period?
I've spoken to Sandra Culver, otherwise no.
Why not, other than Sandra Culver?
I haven't got access to other people other than Sandra Culver.
You say that you've spoken to Sandra Culver. She clearly had first-hand knowledge of the healthcare provision in Brook House during the relevant period, and she'd provided written and indeed live evidence to the inquiry. Did you review her statements?
I did read her statement, yes.
And did you listen to her give live evidence to the inquiry?
Not the entirety of it, but some of it, yes.
Are there any aspects of her evidence with which you disagree?
Not that I recall specifically.
At paragraph 14 of your witness statement, you say this is a corporate statement for the company. It would not therefore be appropriate to comment or speculate on the causes of behaviours of staff employed by other organisations. It's also difficult for me to comment on the causes of staff behaviour in general terms. The conduct of different staff members will likely have been driven by different factors, causes and considerations. Where appropriate, I comment below in relation to particular staff and events. You did feel able to comment at paragraph 31 that the issues identified in relation to Ms. Joanne Buss were in connection with her personal conduct, not systems or policy failures, nor to the best of the company's knowledge and belief were there any issues raised that extended to potential wider issues concerning the company's employees. Is that right?
That is what is stated, certainly.
Did you listen to Joe Buss's evidence to the inquiry?
Yes.
And have you listened to Dr. Hard's evidence to the inquiry?
Not all of it,
But some of it.
but some of it.
Have you read his 2 reports?
Yes.
Do you still think, having listened to and heard that evidence and read his reports, do you still think that there were no systems or policy failures leading to the mistreatment of vulnerable detainees in Brook House in 2017?
I'm not a medical expert and I wasn't there in 2017. I think it's very difficult for me to conclude whether what Dr. Hard that is saying from his desktop review in 2022 is correct or incorrect with regards to exactly what was going on in 2017.
There's been a large amount of evidence from various sources to the inquiry that various safeguards and policy implementation in relation to the safeguarding of vulnerable detainees was failing. Do you disagree with that evidence?
I'm not sure to exactly what you're referring.
Well, maybe we'll come to it in more detail in a moment. Do you have any comment on the evidence that Joe Buss gave that she had heard and not challenged and not reported inappropriate behaviour by detention staff in relation to the incident with D1527 on the 25th of April?
That appears, as represented in the programme, to be shocking, and Sandra Calver appears to have said that she was extremely shocked by Joe Buss's behaviour as well.
Joe Buss gave evidence that seemed to suggest that that type of conduct by her and others was commonplace, and that effectively staff had become, including her, had become immune to it. Does that indicate a system or policy failure in your view, or does that still relate to individual conduct?
I certainly heard Joe Buss refer to it about her own behaviour. I don't recall her specifically suggesting that that was commonplace.
We know from the BBC footage filmed by Callum Tully, including some that was broadcast on Panorama, that various staff members made mocking or derogatory comments in relation to detainees intoxicated by spice. Were you aware of that?
I've seen that comment.
And that's not just by one individual, Joe Buss, it was by other members of healthcare. Again, does that indicate a more widespread cultural or systemic problem at the time?
It's certainly inappropriate behaviour. Whether that indicates a systemic problem or a lack of understanding of the impact of somebody's behaviour or comments on other people. Whether that is a systemic failing, I think I couldn't comment on. I wasn't there.
Paragraphs 43 to 45 of your statement, you state that staffing levels, turnover and the use of agency staff didn't contribute to the mistreatment of detainees. How were you able to come to that view, given that the company and its senior management weren't aware of the mistreatment at the time?
I have talked to the current leadership of our medical business about the way in which contracts, including ones like this one, are staffed. And I understand that it is commonplace across all NHS contracts, including in the NHS itself, for a core of permanent staff to be supported by bank and temporary staff. And in this environment, of course, people couldn't just come in off the street to work. They would have to be inducted anyway in order to work in a secure environment.
Paragraph 67, you state that training failures didn't contribute to the mistreatment of detainees. Again, how were you able to come to that view?
I think there's a variety of insights into what was how the facility was being run at the time. I think that you would have the IMB report and the Her Majesty's Prisons report supported by the CQC. I would have expected, particularly in that case, that the CQC would have talked and required action if they felt training to be inadequate. I don't believe that there was any inference from the HMIP report at the time that there was training inadequacies, and there was certainly no specific action with regards to improving training.
Dr. Hard, in both of his reports and in his live evidence, confirmed that, in his view, there were various inadequacies in the training regarding the adults at risk policy, Rule 35, ACDTs and use of force, which led to failures in the safeguards, leading to detainees remaining in detention, subject to segregation, committing acts of self-harm, and having force used against them, including, for example, in D1527's case, the assault by Jan Pashali. Doesn't that indicate training failures at the time in 2017? Would you agree?
Not sure that Dr. Hard taking a desktop view in 2022 of a situation in 2017 necessarily leads directly to that conclusion. I would have thought that if there were significant failings in the view of the NHS, the Home Office, the IMB and HMIP, that training was such a problem that in one way or another there would have been a significant impact and requirement for the business to change the training methods or improve it.
Sandra Calver gave evidence that the training in relation to Rule 35 wasn't sufficient and that she had pushed for more training at the time. Were you aware of that?
From the research that I've done with regards to this hearing, it seems to me that Rule 35 is a very complex area, and there are many opinions around the way in which it at the time was being implemented and the way that it should still be implemented today. I am aware, obviously, that there was discussion around the training. I'm also aware from the evidence that I've seen that the doctors were keen to discuss Rule 35 with the Home Office and to make sure there was clarity in its implementation and training. So it was clearly an area that wasn't totally crystal in the way in which it was to be implemented and used.
Yes, we'll come to it perhaps in a little more detail in a moment, but at paragraph 75 of your statement, you state that no management failings contributed to the mistreatment of detainees. Again, how were you able to come to that view?
I think with regards to the incidents shown in the Panorama programme, I don't believe that that there has been question with regards to Sandra Calver in particular and her oversight of Nurse Buss. She appears to have been incredibly shocked by her behaviour, and I don't believe that any other issue had been raised with regards to Nurse Buss. Thereby, I think that's how I would conclude that it didn't appear that there were any management failings around that matter.
Are you now aware of Dr. Hard's evidence that management failings led indirectly to the mistreatment of detainees through the failure of the safeguards under Rules 34 and 35? Do you have any comment upon that?
I'm not a medical expert and I wasn't there at the time, but as I have said, it would appear that Rule 34 and 35 weren't entirely clear at the time, and Dr. Hard's view at this time may or may not have been in line with any view that anybody held at that time.
Coming then to Rules 34 and 35 specifically, do you, as a result of your preparation for this inquiry, have an understanding of the interaction between the two rules?
I have read a variety of documents and tried to understand and listened to Dr. Hard and read relevant documents at the time. I think I have a desktop understanding, but I am not a medical expert and I wasn't there at the time, so my understanding will be very limited compared to many other people who would be able to provide a view.
Rule 34 requires that every detainee have a medical examination, a physical and mental examination, within 24 hours of admission to a detention centre. You're aware of that?
I am.
And Rule 35(1) requires a report on anyone where detention is likely to injuriously affect their health, including their mental health. Are you aware of that?
I am.
And in relation to Rule 35(2), that requires a report on anyone suspected of having suicidal intentions. Are you aware of that?
Yes.
Where those thresholds are met, a Rule 35 report should be completed as a direct consequence of the Rule 34 examination at the outset of detention. Are you aware of that?
Yes.
So in that way, the two rules are meant to work together to safeguard vulnerable detainees at the outset of detention. Is that your understanding?
Yes.
Sandra Calver accepted in her evidence a failure of Rule 34, her explanation being that largely there were inadequate resources allowed to give everyone the kind of examination required by the rule, and in particular that the appointment was very brief, being only 5 minutes long. Are you aware of that evidence that she gave?
I'm aware of that evidence. I think at the time, from what I've read, the interpretation shown by Dr. Hard and talked about this inquiry of a substantive mental assessment of every individual arriving at the IRC does not seem to be consistent with what the NHS were talking about at the time in their needs assessment, where they even commented that that the need to see a GP for every detainee entering may be putting an unnecessary burden on GPs. So I find it difficult to square that the NHS, who commissioned the service, were suggesting that there was an unnecessary burden versus Dr. Hard suggesting that there should have been a full mental health assessment of every detainee. So I wasn't there and I can't quite understand how those two things mesh together.
Well, it's not Dr. Hard who is suggesting there should be a mental and physical examination. It's the wording of the rule, isn't it? The Rule 34 requires a mental and physical examination of every detainee within 24 hours of arrival at the IRC. Is that your understanding?
My understanding is that within 24 hours, the detainee should see a GP.
For a mental and physical examination.
For a mental and physical examination. What I'm unclear of, or what I kind of look at and try to process, is what was the intention and how long should that appointment have been? Was it not to assess whether any further assessment was required? And it would appear to me that that was what they were trying to achieve in seeing someone, to assess whether they felt that a further follow-up appointment was required to assess their potential to need to put a Rule 35 report together.
That's clearly what was happening in practice on the ground in 2017. What the rules require, though, is for a Rule 35 report to be completed in appropriate circumstances as a result of the Rule 34 appointment, in order to safeguard vulnerable detainees by identifying them to the Home Office at the outset of detention. That's right, isn't it?
If that is the case, as your reading of the rule suggests, then I find it interesting that still to this day that Sandra Colvig gave the evidence that there still only is 10-minute appointments 5 years later.
Well, indeed, but the rule clearly was being breached at the time and may well still be being breached now. That's the significance of that evidence, isn't it?
If the interpretation of the rule is correct, then of course it is. But I guess what I struggle as a layman to work out is why 5 years later, with all of the focus on this area that there has been, with all of the interested bodies that are engaged in this, why would a change not have been made if that interpretation of the rule is in fact accurate and the way in which it should be implemented?
So, Dr. Uzarali had confirmed that the Rule 34 appointments weren't leading to Rule 35 reports. Instead, as you've said, there was a period where if a disclosure was made or another concern was raised about a vulnerability, a further appointment was booked for a Rule 35 assessment, and that built-in delay, and he described it as being almost like triage. Does G4S Health Services consider that there were adequate GP resources provided at the time to fulfil the requirements of Rule 34?
I think that the resources provided were in line with the contract let by the NHS and were in line with the resources available in the wider IRC estate, and met the needs as people appeared to see them at that time. That may not be the need as you are defining Rule 34 at this time, but appeared to be consistent with across the whole estate.
Dr. Uzarali gave evidence that there was one Rule 35 appointment available a day. Again, did G4S Health Services consider that to be adequate at the time in order to fulfil the requirements of Rules 34 and 35 working together?
It would seem that there was considerable discussion around Rule 34 and 35 at the time, that there was active comparison between Brook House and other IRCs, and that the approach was consistent and typical of the wider estate.
The G4S document at the time on detainee reception procedures was inaccurate in suggesting that detainees must require or request to see a doctor within 24 hours. Would you agree that that's not in accordance with the rule, and therefore that document was inaccurate and therefore inadequate?
Sorry, I believe the document that you describe is inaccurate. My understanding of the process was that a detainee on arrival would be seen by a nurse, and that at that point the nurse would make an appointment for them to see the doctor. So if the document did not reflect that process, then it would appear that the document wasn't reflecting what was done at the time.
Yes. There was some evidence the inquiries heard from Medical Justice from their casework experience that detainees weren't always seen for a Rule 34 appointment within 24 hours, and that sometimes even where a disclosure such as being a victim of torture was made, a Rule 35 assessment wasn't booked for them. Again, that would have been inadequate at the time to comply with the rules, wouldn't it?
If the detainee wasn't seen within 24 hours, indeed the rule does say within 24 hours. In terms of if someone has disclosed torture, I'm not clear that that necessarily directly leads to a Rule 35 assessment, because if there is no fear of the mental well-being of the individual from their behaviour and state, would that necessarily lead there? I'm not an expert, I wasn't there, and I'm not sure that that would necessarily happen.
If someone had disclosed they were a victim of torture, you don't think it was necessary for them to be assessed under Rule 35(3) at the time?
My understanding of Rule 35, and it may be my misunderstanding, was that the purpose of Rule 35(3) was to raise that as a reason that the individual should be released from detention, because further detention would further harm them. I'm not clear that is always the case of somebody who has suffered historic torture, but I'm not an expert.
Would you accept from the evidence that the inquiries heard from various sources that the rules weren't working at the outset of detention to identify to the Home Office those who were vulnerable and at risk of harm in detention, and so weren't safeguarding detainees at that stage?
I don't know that I can comment.
Was senior management aware of how the rules were operating at the time on the ground in 2017?
I'm not sure what I can point to establish what level of conversation was or wasn't going on with regards to those specific matters in 2017. Obviously, there were a number of reports produced and reviews undertaken, and I don't remember in my reading of any of those reports it to have been something which was of significant concern or record that created substantive action. Therefore, I'm not sure that it would necessarily have been something which was high on the agenda for discussion at a senior level.
Stephen Shaw had in his January 2016 report looked at Rules 34 and 35 and had noted that they were intended to be a key safeguard in ensuring that vulnerabilities were identified in detainees to the Home Office, but that it was abundantly clear that Rule 35 was not fit for purpose and was failing to protect vulnerable people who find themselves in detention. Was G4S Health Services at a senior management level aware of those findings in the Shaw report at the time?
I unfortunately wasn't there at the time of the Shaw report, and I haven't been able to speak to anybody who was there to know the answer to that question.
Do you know if anything was done by G4S Health Services to respond to the failures that a Rule 34 and 35 process identified by Mr. Shaw in that review?
I don't know with specific reference to the Shaw review. I do, of course, know from Dr. Uzarali's evidence that he was trying to engage with the Home Office to discuss the effectiveness of Rule 35.
He's not senior management in G4S Health Services, though, is he, Dr. Uzarali?
No.
Do you know of any action taken by senior management in G4S Health Services to respond to those findings by Mr. Shaw in 2016?
No, I don't believe. I haven't spoken to anyone who was in senior management at that time, and I don't know what action was or wasn't taken with regards to that report.
There's nothing apparent from your review of the documentation?
My review concentrated on the relevant period. I didn't review anything particularly unless I was guided to it outside of the relevant period.
You state at paragraph 181 of your statement that the majority of self-harm incidents did not meet the threshold for a Rule 35(2) report of real suicidal intent. What's the basis of that statement?
I understand that a doctor would talk to the individual and assess in his medical opinion the intent and likelihood of further harm from such action. I believe that is what I referred to in my statement at that point.
If we could show on screen, please, CJS 006120. These are the detention centre rules. If we could go to page 11, please. Rule 35 is in the middle. Rule 35(2) requires the medical practitioner to report to the manager on the case of any detained person he suspects of having suicidal intentions. The rule requires only a suspicion of suicidal intentions, doesn't it?
It does.
Your statement at paragraph 181 that the majority of self-harm incidents did not meet the threshold for Rule 35(2) of real suicidal intent doesn't, though, address the very low numbers of Rule 35(1) reports, does it?
And the fact that they would be injuriously affected by continued detention, no.
Because Rule 35(1) only requires a likelihood of harm, not even actual harm to have been caused. We see that from the rule, don't we?
We do.
And we know that there were only 8 Rule 35(1) reports in 2017, only 2 in the relevant period. And we know there were no Rule 35(2) reports at all in 2017. And we know that despite high levels of self-harm and a large number of open ACDTs, 248 in 2017, evidence heard by the inquiry from Sandra Calver indicated that she, and indeed her staff, hadn't understood the Rule 35 process and were applying too high a threshold for Rule 35 reports to be completed. Are you aware of that evidence?
I'm not aware of that particular piece of evidence from Sandra. I'm aware of the concern that you are talking of there. from my reading of the documentation around that, it would appear that that concern was discussed at the IRC forums and that the relative numbers were comparable with the numbers reported across the wider IRC estate at the time. I'm also cognizant of the evidence from Dr. Uzarali where he talks about his use of Part C rather than 35(1) or 2. It appears from what I've seen him talk about that he felt that was a quicker way to gain attention and discussion of specific instances.
Part C, though, of course, doesn't require a review of detention, does it, by the Home Office? Rule 35 does. Are you aware of that?
I think, as I say, this is a complex area. I'm not an expert in the area, and it is difficult for me to make clear commentary on it. All I can say is that as an observer and listening to Dr. Uzarali, he seemed to have the opinion at the time that completing a Part C and sending it to the same Home Office inbox as a Rule 35, that it will be read by the same person and generate action. Obviously, I can fully understand that there is a different interpretation and a requirement of action from Rule 35 as talked about here. I guess there's a difference of interpretation versus practice at the time, and I would normally have expected engagement between the Home Office, the NHS and other bodies to have brought that to the fore and brought that as an improvement point, which didn't appear to be happening for some reason.
What evidence are you aware of that senior management at G4S Health Services were raising that issue with anyone?
I'm not aware.
Sandra Calver accepted that regarding Rules 35.1 and Rule 35.2 that there should have been significantly more of both of those types of report in 2017 and that the safeguards had failed. Do you agree with her?
I don't recall that particular piece of Sandra's evidence. I can certainly see from the interpretations being taken here that it would be reasonable to have expected higher numbers. As I said, it would appear that the numbers that were reported at Brook House were not inconsistent with the numbers reported across the wider estate, and as such I would have expected there to have been considerable effort from other parties to have raised this and to be taking action if it was in fact a problem that was only at Brook House.
Whether or not there were failures in the safeguards at other IRCs, do you accept that they were failing in 2017 in Brook House?
I guess the reason that I'm labouring this is I'm trying to look back 5 years and apply the lens of what was considered to be acceptable and normal 5 years ago versus what might be considered to be the lens of a review and detailed desktop questioning today. And I'm not sure that a view that would be taken today in this room would necessarily have been the exact same view and interpretation taken by people actually operating the service at the time in 2017.
Whether or not it was their view that they were operating it acceptably, do you accept now that the rules were not being complied with in 2017 in terms of the reporting under Rule 35.1 and Rule 35.2 to the Home Office?
By the definitions of which you are interpreting those rules, I can see how you reach that conclusion. I find it difficult to understand why, if those rules were being so blatantly missed, why is it that the inspections of the IMB, Her Majesty's Inspectorate and the CQC did not raise these as being serious failings at the time? I would have fully expected that level of oversight and the regular reviews that were undertaken on a quarterly partnership and the quality meetings to have been raising those as serious issues. So the sheer fact that so many other modes of oversight were not raising it makes it, for me as a layman at this time, a confusing picture to try and dissect.
The statement that the majority of self-harm incidents in 2017 didn't meet the threshold criteria for Rule 35(2) doesn't address the fact that there were in fact no Rule 35(2) reports in 2017, does it? You're not suggesting that there were no detainees in 2017 in Brook House about whom there was a suspicion that they had suicidal intentions, are you?
No, I don't believe that Dr. Uzerali suggested that. I believe that he suggested, from what I've seen in his evidence, that he rather used Part C, and as you're saying, that may not have been the intention of the rules at the time, but appears to be how he interpreted it.
Yes, because we know that there were a number of detainees who the inquiries heard about, for example, D1527, D1914 and D687, who were identified as having made a statement or an attempt to kill themselves and were managed on constant supervision on an ACDT, indicating a high risk of suicide. Are you aware of that?
Yes.
And so in those cases and those types of cases, there should have been a Rule 35(2) report completed at the time, shouldn't there? Do you accept that now?
By that interpretation, yes. I'm not sure whether a Part C was completed for those cases, which would have been the evidence from Dr. Uzerali of the approach he would typically have taken at the time.
But whether or not a Part C was or wasn't completed, the rules require a report where there is a suspicion of suicidal intention. And in those cases where detainees were managed on constant supervision, that threshold was met, wasn't it?
I'm not sure.
Are you aware now as to whether at the time in 2017 senior management in G4S Health Services were indeed aware of the low numbers of 35(1) reports and that there were no Rule 35(2) reports undertaken? Are you able to say whether they were or were not aware?
I don't know.
And your explanation for the lack of those reports was that there was an understanding by those at the time, accepted in the knowledge of the Home Office, that that's the way it was done, and that so it wasn't a problem.
That is the only inference that I can take from the lack of it being raised through any other channel as being an important matter to resolve, because otherwise, as you suggest, it looks obvious that there was a problem. But if there was a problem of the scale that has been described, I continue to struggle to understand why it wasn't being brought to the attention of everybody as a serious failing, because there was no lack of oversight, of detailed reporting, and of review of what was going on in the establishment at the time.
If senior management weren't aware of the low numbers indicating a lack of compliance with the rules, they should have been, shouldn't they, at the time?
As I said, I would expect that they would have been, but I can't evidence whether they did or whether they didn't. I don't know what reports they read or what level of insight they had into the detail of what was going on at Brook House at the time.
Some responsibility for compliance with the rules by those on the ground rests with senior management of the company, doesn't it?
Yes, it does. And I reiterate, I don't know whether they did or whether they didn't, and I don't know what action they took.
Well, given the evidence the inquiries heard that health services, that healthcare staff, including the head of healthcare and clinical lead, leadership roles in healthcare, didn't understand how to apply the rules, and GPs on the ground weren't applying them under Rules 35(1) and 2, would you accept that there was a failure of senior management in that regard?
I'm afraid I find it difficult in such an environment, in a medical environment where the medical director and clinical people would be in constant touch with the NHS, the Home Office, and other oversight bodies, the CQC, that if this was such a well understood and well and documented in a way that creates such an expectation, then I'm sure that it would have been a point of discussion and an action would have thereby flowed from it. I'm not sure that I can infer, due to the lack of action and required action from any of those oversight, that I would expect there therefore to have been any action taken by the senior leadership of health services.
But wasn't it senior management's responsibility, irrespective of what any other body was doing, to ensure that its staff were complying with their statutory obligations under the rules?
Yes, of course, but if at the time the rules were being interpreted and enacted in a certain way across the whole IRC estate, which was understood from forums and other actions, then that would have been the interpretation of the rule at the time. If with hindsight and 5 years on, we now consider that to be an incorrect interpretation, that could well be so, but that was not necessarily the view taken by any organisation at that time.
Did G4S Health Services monitor the training being given to staff on Rule 35?
I believe that there was a training matrix, and that as in all medical settings, training was important, and I would believe that Rule 35 training would have been monitored in the same way as other training.
Was there any monitoring from senior management of compliance with Rule 35? Was that audited at the time?
I haven't seen the detail of any audit documents.
How then were the senior management of G4S Health Services ensuring that the legal duties under that rule were being complied with on the ground?
I don't know.
You say at paragraph 57 of your statement that there were no contract compliance issues with Dr. PA Limited, who provided the GP services in Brook House at the time. Did G4S Health Services review Dr. PA or the GP's compliance with Rule 35 at the time in 2017?
I believe there was a close working relationship between Dr. PA and the health services business, that there were daily reviews of practice, that there were quarterly quality reviews, and there were quarterly partnership reviews which were attended by oversight bodies. I'm not aware as to, across all of those different reviews and audits, as to what specifically was reviewed with regards to Rule 35. It would be surprising if it wasn't covered in some way through that amount of oversight and engagement.
Because it doesn't appear that oversight and engagement to have picked up a complete lack of Rule 35-2 reports and only 8 Rule 35-1 reports in the whole of 2017, does it? Does that suggest a failure of that oversight mechanism of the contract compliance or in relation to the GPs at Brook House in 2017?
No, I don't think it does. I think it further points to the interpretation of Rule 35 at the time across the whole estate. Because if, as you suggest, there was such a failing, I cannot see how the CQC, the NHS, or Her Majesty's Inspectorate, none of them decided that there was a significant failing that required action in this matter. They were also aware of the number of reports, as they were the number of reports across the wider IRC estate, and I understand that the number that were quoted out of Brook House were not untypical. In fact, in the wider use of Rule 35, I believe that Brook House had more reports converted into detainees being released than anywhere else.
You say at paragraph 56 that any significant performance issues or complaints concerning GPs were referred to the company's medical director. Were there any complaints about Dr. Uzerali or Dr. Chowdhury concerning Rule 35 reports or the lack thereof?
Not that I'm aware of in the relevant period.
Was it picked up as a performance issue by senior management at G4S Health Services?
As I reiterate, I don't believe it was picked up by anybody as being a failing.
But it should have been by senior management, shouldn't it? They did bear some responsibility for those on the ground complying with their obligations under the rules. Can't just blame it all on everyone else.
Well, I'm not blaming it on everyone else. I'm trying to consider the environment that if the way in which the rule at the time was interpreted was consistent with as was expected by the oversight bodies and as was expected and seen in the wider IRC estate, then why would we then seek to interpret it in a different way? It's clear that there was discussion about Rule 35 and that Dr. Uzerali gave evidence talking about wanting to engage with the Home Office about Rule 35. So there was clearly some issue and discussion around it. So on the basis that there was issue and discussion around it and that there was training which was subsequently provided in 2018, it's obvious there was engagement and there was real discussion happening. So in that sense, it would suggest that there was action and awareness as to exactly how that was being interpreted and how that was being reported and whether that therefore could create an inference that there was a failing. I'm not sure that I can join the dots that create a failing from that because there was so much talk around it.
But
it's not like it was ignored, is what I'm saying.
But that didn't result in compliance with the rules. Would you accept that?
As the rule is defined today in 2022, and as it can be read.
And it's not changed since 2017.
No, but we are now in version 7 of a document that was in version 4 in 2017. So there's clearly a lot gone on around the whole Rule 35 thing and continues to be so in the fact we've been talking about it for so long.
But the wording of the rule remained the same in 2017 as it does now. And whatever discussion there was between senior management and any other body, it didn't result in compliance with the rules, did it, in 2017?
I think it's about the way in which the rule was being interpreted and implemented. And I think from what I could infer, that from Dr. Uzerali's evidence as I saw it, he talked about the use of Part C. Now that may not have been appropriate, that may not have been in line with the rule, but that would appear to be the way in which he interpreted and what he did.
Do you think that senior management at G4S Health Services was aware of that practice at the time?
I couldn't conclusively evidence that to be the case. However, there was a close working relationship between G4S and Dr. PA, and I would be surprised if they weren't aware of that.
Sandra Calver gave evidence that, along with herself as head of healthcare, the Home Office bore some responsibility for failings within the Rule 35 process in that they had been aware of the practice being undertaken in Brook House through her involvement with the IRC forums, as you've alluded to. Do you agree with her that the Home Office bears responsibility as well?
I think that this is a complex matter, and I think the lack of clarity certainly didn't help.
Sandra Calver gave evidence that as a result of the lack of Rule 35.2 reports being completed, she created a Rule 35.2 pathway document, and that she brought that to the attention of the Home Office at an IRC forum who approved it. Was senior management at G4S Health Services aware of the use of that pathway at the time?
I can't evidence that to be the case, but I would assume so.
On what basis?
That Sandra's talked about it in the manner in which she did. And that she felt the need to create the document to gain consistency. It was obviously a point of discussion.
She accepted in evidence that it didn't comply strictly with the rule because it built in a delay in reporting with a step of a nurse referral prior to a GP being seen 7 days after the detainee was put on an ACDT. Were you aware, as were G4S Health Services senior management aware at the time, that that pathway didn't comply with the wording of the rule?
I don't know, but I think it's taking the rule strictly. I can see how you suggest the pathway doesn't apply to the rule. However, if the individual is already on an ACDT and is under constant supervision, then I guess that from what I can understand from the intent there was to understand whether the individual was at genuine risk of a suicide attempt. And I don't think it was strictly 7 days, was it? It was up to 7 days. It was trying to, I guess, assess the individual from my reading of that. But my reading may be wrong, and I may have misinterpreted it.
Can I look at use of force, please? At paragraph 172 of your witness statement, you deal with the F213 form and that some forms were missing or not completed during the relevant period. And you speculated there as to the possible reasons for that. Has G4S Health Services taken any steps to ascertain the actual reasons that they were missing or not completed at the time? Was there any investigation of that?
No, I don't believe there was. I think we are, of course, as we've said in there, we're 5 years on. They're documents amongst many, and as I understand it, of all the documents requested by the inquiry in terms of the F213, less than 10 were missing. So it wouldn't suggest that there was a serious issue of a complete lack of documentation.
Has there been any audit of the use of force paperwork undertaken to ascertain if healthcare were completing the forms on all occasions?
I don't know. That would have been done by CJS.
Or as to the quality of the entries?
Again, I don't know.
Because isn't the healthcare aspect of those forms important, and the responsibility of senior management of G4S Health Services as opposed to Care and Justice?
The quality of all the documentation to do with health is important. It's to do with an individual's welfare, and as such, of course, it's important.
So wasn't it important to audit the quality of those entries? The healthcare entry on the use of force form?
I'm sure that the quality of all health documentation is important. I'd be surprised if it wasn't audited in some way, shape or form.
In the minutes from a meeting on the 27th of October 2016, it was stated that Rule 40s, Rule 42s and 213s are still not being completed on all occasions. Are you aware of what action G4S Health Services took as a result of that being minuted in that meeting in relation to a failure to complete the forms?
Sorry, can you just repeat that?
So in the minutes of a meeting from the 27th of October 2016, it was stated that Rule 40s, Rule 42s and 213s are still not being completed on all occasions. And I was asking whether you are aware of any action taken by G4S Health Services in relation to the failure to complete those forms.
No, unfortunately, I wasn't around in 2016.
And there's no documentation available as to what action, if any, was taken by G4S Health Services as a result of it being recorded in a meeting that was the case.
I don't remember reviewing documentation from 2016.
Dr. Uzarali on the 27th of May 2017, within the relevant period, completed a fitness to fly letter in relation to D1914. And in that letter he stated the above detainee is fit to fly and fit for detention. He will need a medical escort due to the nature of his medical condition. I am happy for reasonable force to be used, CNR, in order to facilitate the removal. Was the senior management of G4S Health Services aware of the practice of GPs in providing such letters to the Home Office in 2017?
I don't know the specifics of operational detail at that level.
That would have been a concern at the time, wouldn't it?
In what way?
Wouldn't it be important for senior management at G4S Health Services to be aware of the practice of GPs of completing such letters for the Home Office in relation to patients?
I don't know.
Dr. Uzarali, as I've said, stated there that he was happy for reasonable force to be used, which effectively approves or sanctions the use of force on D1914 to effect his removal. Would you agree?
That could be inferred from what you read.
It certainly goes beyond expressing a concern or a contraindication, a reason not to use force, doesn't it? Yes. Indeed, he doesn't raise any concerns or contraindications, reasons not to use force. Was senior management in G4S Health Services aware of that practice by GPs in 2017, that there was an effective approval of use of force on detainees?
I don't know.
If they were, would that have been of concern?
I guess I don't understand the context in which the letter was written. I don't see what questions were asked, and I don't know what he was responding to. So, in the context in which you ask the question, yes, of course it's concerning, but not understanding the wider context around why was that written in that way at that time with respect to that particular individual, I don't know.
Have you reviewed the evidence of Dr. Bingham and Dr. Hard on this issue to this inquiry?
I can't bring it immediately to mind.
They certainly said that this went beyond what was appropriate for a doctor, and that here Dr. Uzarali should have been raising concerns and contraindications due to both his physical and mental health history. You weren't aware of that?
No, obviously they're qualified doctors providing medical opinions about another doctor. I haven't seen the detail. I don't know what detail they've seen to reach that conclusion either.
Are you aware of how many times the medical emergency hands-off instruction was used by healthcare staff in 2017?
No.
Why not? Was that not something you expect to be recorded?
I don't know whether it was recorded. I certainly haven't seen any registers as such. I'm aware it was the action that was expected to be taken if there was a problem with use of force.
There wasn't any audit of how many times and in what circumstances those instructions were required to be being used by healthcare staff in 2017?
I don't know.
What action did senior management in G4S Health Services take to follow up on such an instruction having been given during a use of force?
I understand that there would have been a debrief and a review.
And what action would senior management take as a result of that?
I don't know what specific action they would have taken. I don't know, because I haven't got any record of it happening or what action would have been taken.
Are you aware of any other support other than the debrief being offered to healthcare staff who were required to issue such instructions at the time?
No, I do remember some reference to it in a document, but I don't recall the detail of that, I'm sorry.
How was G4S senior management learning lessons from such situations?
I don't know how senior management were learning lessons. Sandra Culver comes across to me as being a very credible and caring manager, and I would have thought that as the manager on site, with the regular reviews of her staff and continual development of them, that there would have been discussion around those areas. And I think we probably saw it in some of the minutes of some of the staff meetings about talking about a variety of issues.
Was any training provided to healthcare staff about their particular role in a use of force by G4S Health Services?
I think this is an area that we relied on CJS to provide training and insight into. As I recall from the information, that is the way in which individuals would have been trained by CJS.
If they're not healthcare professionals with healthcare expertise, are they? How would they provide training to healthcare staff on their particular role in a use of force?
I don't know.
In relation to the authorisation of use of force and the authorisation of removal from association under Rule 40 and authorisation of temporary confinement under Rule 42, what is your understanding of who is able to authorise those aspects under those rules?
I think from my understanding that Rule 40 and 42 were enacted by CJS.
The relevant DSO suggests that in normal circumstances, use of Rule 40 or Rule 42 must be authorised by a manager from the compliance team at the Home Office, but in cases of urgency in which it's impractical to seek authority from the Home Office, it could be done by G4S, and urgency was defined as, for example, to protect life and or the security of the centre, for example, a fight or an assault on another detained individual or member of staff. So far as you're aware, at the time, was that what happened?
I haven't seen anything to the contrary.
In what circumstances would it have been impractical to seek authorisation or authority from the Home Office?
I don't know. I'm not aware of just how close and available the Home Office was to the day-to-day operation.
Do you have an understanding of who would seek such an authority from the Home Office?
No.
Was it your understanding that detention centre managers could authorise force, removal from association and temporary confinement under these rules?
As you've just read them, yes, I believe that to be the case if there was a particular and immediate need.
You state in your second witness statement at paragraph 4 that 3 different organisations bid for the GP contract and that the doctors to be provided by Dr. PA were the same doctors that were delivering services within Brook. So this provided for an element of consistency and continuity of service, is that right?
Yes.
What other factors influenced you in choosing that bid? Or influenced G4S Health Services, I should say, at the time?
I wasn't there. I don't know the detail of the tender. I know that there were 2 other organisations that tendered, I would imagine that there would have been a mix of factors which would have generated the decision.
Such as?
I would imagine in any tender of its type, there would be a blend of quality, capability and price considerations.
The 2016 IMB report had raised issues about the Rule 35 process in Brook House. At paragraph 5.4.10, they said, "It is surprising that there are so few reports by GPs about detainees whose health is likely to be affected by continuing detention or suspecting that a detainee has suicidal intentions, given that reporting from G4S showed an average of 11 incidents of self-harm attempts per month in 2016. So there we have an example of the IMB in 2016 raising issues with the number of reports under Rule 35. Would you agree?
Yes.
Did that, to your knowledge, raise any concerns within G4S Health Services about giving the contract to the company owned by the two existing GPs in Brook House at that time?
I'm not aware that it did, no. Remembering those GPs weren't just working in Brook House, but were working in the wider IRC estate.
Should that have been a concern in awarding them the contract, what the IMB had recorded there?
As I've said, I don't think from what I've read and understood that the practice was inconsistent with the practice in the wider IRC estate at the time. Whether it was right or not, obviously, we're discussing and I don't know. But if it was consistent with the wider practice in the wider IRC estate, then I'm not sure why it would have been a cautionary point with regards to the appointment of the doctors.
Well, you mentioned earlier in your evidence that there was clearly a reliance upon the IMB not raising concerns, and we see that they did in fact raise concerns, didn't they?
They raised a note of surprise, didn't they? That's somewhat short of raising a direct concern around the performance of the organisation.
Are you aware of whether or not that note of surprise was raised at all with the GPs from Dr. PA Limited by G4S Health Services at the time?
I have no evidence to suggest whether that was true or not. I would be very surprised if a report of that type wasn't raised in both the quarterly quality meeting and the partnering meeting, especially with a wider attendance at the partnering meetings. But I haven't reviewed any minutes of any of those meetings to be able to confirm or deny that.
At paragraph 120 of your first statement in relation to the Lampard report, which reported on the nature of detainee complaints concerning healthcare, you stated that the company can't respond to specific comments without knowledge of the detainees, their medical history or the context of the discussions. Does G4S Health Services accept that there was any substance to detainee complaints about healthcare in 2017?
Sorry, can you repeat the question?
Does G4S Health Services accept that there was any substance to detainees' complaints about healthcare in 2017?
From what I can understand, we took complaints seriously, and each complaint was reviewed by an independent reviewer, so it would seem that we were taking complaints seriously.
On some of the footage we've seen, both on panorama and on the unbroadcast footage, there was evidence of a mocking and derogatory attitude by some healthcare staff towards detainees who were unwell, particularly intoxicated with spice. Sandra Calver certainly accepted that in her evidence that those comments were inappropriate. Was G4S Health Services senior management aware of that type of behaviour from some members of healthcare towards detainees in 2017?
I can't comment on whether it was aware. It was clearly unacceptable.
Some formerly detained persons have given evidence to the inquiry of rude or dismissive or abusive attitudes by healthcare staff to them. Do you have any comment upon that?
I think there is no place for unacceptable behaviour by healthcare staff in towards any patient. I think that the line that must be drawn, however, is the concept around dismissive or brusque. That could be regarding a style rather than an actual intent. So I think anything that is rude is and inappropriate is completely unacceptable. However, I think that the inference about somebody who is busy, who is trying to do many things, appearing to be brusque, is not maybe the best example of how you would hope that somebody would conduct themselves, but isn't necessarily a reference to their intent or ability to deliver a healthcare service.
Did G4S Health Services at the time seek to investigate the nature of detainees' complaints to ascertain whether any action was needed at a systemic level?
I believe that the complaints were taken seriously and reviewed at quarterly complaints reviews in the quality meeting. So I would be very surprised if there wasn't a thematic and systemic review of those, but I have no evidence to prove that that would be the case.
In a complaints audit undertaken by the company in 2020, it's recorded that the majority of complaints at Gatwick IRCs related to the failure to treat, with the second most common reason being staff attitude. And it stated, considering a complaint, do we actively listen, seek and act on feedback? The report records no evidence that complaints were being reviewed at quality or board meetings. Were complaints being reviewed at quality or board meetings?
If that is the view taken in the 2020 report, then at that time they can't have been. Obviously, I don't know whether that was the case in 2017. We obviously had a managing director in 2017, a different managing director in 2019, who unfortunately passed away, and we were on the third leadership at the time, so it may be something that was done and had passed. I know that following that report, a full review was taken of the complaints process, and a number of items that have been brought up on that report have since been rectified, and the whole complaints procedure across the business has been changed.
The report says that there wasn't any formal collation of complaint outcomes and triangulation with patient safety and patient experience data. Is that something that's changed now?
I believe so. That report does not make good reading. I believe the only thing I took from reading that report was that actually Gatwick was probably the best performing of our establishments with regards to complaints.
At paragraphs 21 and 22 of your statement, you deal with the root cause analysis investigation that was carried out following the Panorama programme, and you say that the company was required to submit a root cause analysis, which is an NHS-led document reporting tool designed to capture serious incidents. Its purpose is to demonstrate good governance and safety, and to also demonstrate lessons learned. The report was delayed because of the ongoing police investigation, and then you then say due to loss of knowledge and healthcare's limited role in the police investigation, which was led primarily through CJS, the company is unable to say when clearance to proceed was given, but following this, Ms. Hill was commissioned to conduct the required RCA investigation. However, following her departure from the company, it was identified this did not appear to have been done. Ms. Hill, was she the Director of Nursing?
She was.
Do you know when she was commissioned to undertake the RCA investigation?
No, I don't.
What were her qualifications and experience?
I'm afraid I don't know.
She left the company in November 2018. She reported to Tom Tuppen, who was the managing director at the time. Is that right?
That's correct.
Why didn't he follow up on the RCA before she left? Do you know?
No.
The RCA was belatedly carried out by two other senior members of staff, and a report dated May 2019 was submitted. Was that the only review carried out by G4S Health Services as a result of the Panorama programme?
I don't know. I do find it very surprising that Ms Hill didn't do the RCA, but obviously we can't evidence it because we can't find the document. So I don't know what other reviews may or may not have been undertaken. Obviously Health Services were involved in all of the activities in G4S with regards to reviewing the Panorama programme and actions afterwards.
The RCA report found that contributory factors to the failure to treat detainees with respect and dignity included lack of attention to dignity and respect systemically across the IRC, and it identified root causes as staff cultural institutionalisation across the IRC more widely led to patients not being treated with dignity and respect. Staff were not supported to deliver safe and compassionate care. There was a failure of speaking up and reporting concerns or complaint systems, a dysfunctional atmosphere and culture that enabled bullying and blame systemically across the IRC. Does the company accept the findings of the RCA?
The RCA was conducted in 2019 by two senior managers who I think were seeking to do, well, the mode of the RCA took a much wider review of both the healthcare and the functioning of the IRC. From what I can see through interviewing everybody, it is clear that its view about the wider IRC and where it was an important observation, and I believe action followed.
The question was, does the company accept the findings of the RCA?
I think we accept the findings. I think it's in the context of it being an RCA that I struggle with.
It went wider than just looking at the particular incident.
Yes.
But the findings were nevertheless accepted.
I believe so.
What action was taken to address those contributory factors and root causes by the senior management of G4S Health Services as a result of that RCA?
I believe that that Mr. Cook continued to work with Sandra regarding the outcomes, but to be honest, I can't remember in detail.
I want to look at staffing briefly. Did G4S Health Services in 2017 have any system in place for documenting and monitoring the staffing levels in healthcare in each separate institution?
There's a document that's been submitted that showed the rostering by staff type in Tinsley and Brook House, if that's what you mean.
Was there a system for auditing or monitoring the care and treatment received by detained people by agency nurses as opposed to permanent members of staff?
I don't believe so.
In 2017, some nurses didn't have training on the role of a nurse during control and restraint because the instructors of those courses had been suspended or dismissed because of their conduct captured in the Panorama programme. Did any review take place of whether those who had received that training from those people who had been suspended or dismissed take place to see if they needed repeat training?
I don't know. I do remember from some minutes in October 2017 that the Deputy Director of the prison undertook some training with all of the healthcare staff.
That was Steve Skitt, the Deputy Director. Is that right?
I believe so.
Was the Deputy Director sufficiently qualified to give that training, in your view, given he's not a qualified nurse or a use of force instructor?
I don't know. I think he was trying to fill a gap because there was a gap because of the people that have been suspended and left the organisation. And
in relation to HMIP, the HMIP Service Improvement Plan in 2017 made recommendations that there should be a health needs analysis and a centre health and well-being strategy. Do you consider that there'd been a failure by G4S to not already have identified that need previously?
I think the health needs analysis was conducted by the NHS. I think there'd previously been a health needs analysis in 2015. I don't know what the expected frequency of a health needs analysis would be, I'm afraid, in a medical setting.
Paragraph 126 of your witness statement, you say that in relation to the oversight of healthcare at Brook House by HMIP, all healthcare actions from the HMIP inspections of 2016 and 2019 were completed. Is that right?
I believe that's what I stated.
In 2016, the HMIP report at paragraph 1.71 stated that the Rule 35 reports they reviewed did not provide an adequate safeguard for detainees with post-traumatic stress disorder, and no formal assessment of PTSD had been carried out in any case, and a recommendation was made at paragraph 1.80 stating that where a detainee claims that they have been tortured, the Rule 35 report should include an assessment of PTSD. Were you aware of that finding and recommendation?
Not in detail.
On page 36 at paragraph 2.37 in that same report, it was stated that complaints about health services were submitted through the general centre system and forwarded to NHS England, which then returned them to Healthcare for investigation. This compromised medical confidentiality and led to unnecessary delays in responses, so that some detainees had left before the responses arrived, and a recommendation was made in that regard on the same page at paragraph 2.42, stating that the healthcare complaint system should maintain medical confidentiality. Were you aware of that finding and recommendation in the 2016 report?
Not in detail.
On page 36 at paragraph 2.38, it was stated there was no centre wellbeing strategy, but health promotion information was displayed in the health centre largely in English. We were told that some information could be provided in other languages. There was no self-care and wellbeing guidance in the library in any language, and a recommendation was made detainees who do not speak or read English well should have reasonable access to translated information about health services and health and well-being. Were you aware of that?
Yeah, I believe that we submitted a number of documents that were in a variety of languages.
As a result, some leaflets were published in other languages. Is that right?
I believe so.
Why had G4S Health Services not identified that as a need previously?
I don't know.
It seems like a relatively obvious proposition that detainees should have access to information in a form they can understand, doesn't it?
I would accept that. I do believe that that the main reliance was on translation services in order to engage with detainees in their language, and I believe we used two different translation services, and that was the primary way in which we ensured communication in an appropriate language.
In relation to the statement that all actions from the 2016 report were completed, as you say at paragraph 126, they were assessed in the 2019 HMIP report. And on page 61, it was stated in relation to progress from recommendations in the previous report, where a detainee claims they have been tortured, the Rule 35 report should include an assessment of PTSD. Where there is independent evidence of torture, the Home Office should only detain in very exceptional circumstances. Reasons for maintaining detention in such cases should be comprehensive, and it was recorded not achieved. Were you aware of that?
That is in the 2019 report, as you say, yes.
On page 61, it also stated the healthcare complaint system should maintain medical confidentiality, and it stated partially achieved. Were you aware of that?
Yes.
And on page 62, detainees who do not speak or read English well should have reasonable access to translated information about health services and health and well-being. Again, partially achieved. Again, in those circumstances, is it really correct to say, as you do at paragraph 126, that all actions from both reports have been completed?
Well, I guess in terms of the last one, the company clearly didn't reach the level at which the IMB expected us to have reached in completing that. However, as you commented on, the company had completed leaflets and made sure that both translation services were available. I guess that would be the company's interpretation at the time versus the expectation to meet the need.
At paragraph 122 of your first statement, you say some detainees would seek to get fast-tracked through the NHS to get onto a hospital waiting list for treatment, on the assumption that being on such a waiting list would prevent deportation until the treatment had been provided, and or seek to stay in the UK until the treatment had been provided. Would there also have been occasions where there was a genuine need for the assessment and treatment of detainees?
Indeed, and I think the doctors were trying to meet the need of the detainees as much as possible.
On what evidence did you base the statement that they were seeking to get treatment solely to prevent or delay deportation?
I believe that would have been an assertion made from my inquiries with Sandra.
In relation to complaints, matters of serious matters for concern were raised with NHS England in terms of complaints. If a complaint was serious, it would be passed on to NHS England to investigate. Are you aware of how many there were in 2017 passed to NHS England?
I don't think any were in 2017.
Was there any policy to guide the use of the discretion about when there should be a referral of serious concerns by the head of healthcare to NHS England? What guidance was given as to the threshold?
I don't know.
Was any training provided?
I don't know.
Thank you, Mrs. Sharland. Yeah, mine has stopped as well. Okay, we'll just pause momentarily and see if we can get it back online. Thank you.
Chair, given we have to pause, it may be that that's a good opportunity to have our afternoon short break.
Good idea.
Can I say 25 to 4, please?
Okay, thank you very much. Thank you. See, thank you.
Thank you. Mr. Dove, were you aware that when the clinical lead, Chrissy Williams, would conduct investigations into complaints in Brook House in 2017, that she wouldn't speak to the detained person who had made the complaint, but it would only speak to staff members?
No, I was not aware.
And that she wouldn't always require any formal statement to be taken, only if it was a serious issue? Were you aware of that
No.
in 2017? Do you think that's an appropriate way to conduct complaints investigations?
I think depending on the nature of the complaint, if it's a complaint that just requires the review of some documentation or an approach, then it may be appropriate, but I can imagine in many cases that there would be a point at which speaking to the detained individual would be very useful. But I don't know what the policy was at the time.
In relation to medical justice, G4S Health Services received a number of clinical letters and medico-legal reports from medical justice in relation to their clients in the relevant period. Do you know if G4S Health Service ever responded to any of those to medical justice?
No, I don't know.
Do you know if G4S Health Services ever approached medical justice as an organisation to discuss any aspect of the recurring issues that arose in those letters and medico-legal reports?
No, I don't know.
If they didn't, would you have any knowledge of the reasons why they didn't?
No, I would have no knowledge at all.
Brook House was and indeed is a closed institution, so of course medical justice wouldn't have any access to documentation at Brook House, including medical documentation, beyond the individual cases that they were involved in, would they?
I believe not.
So I just want to ask you what you mean at paragraph 147 of your report by saying the company would have welcomed such input, meaningful input from external bodies which would have improved effective oversight and governance, and it's disappointing that such bodies in which you included medical justice didn't provide any such meaningful input. What input could they have given in the circumstances that would have been more meaningful than what they were already doing?
I don't know.
You say at paragraph 155 of your statement that there was a disconnect between medical justice statements on fitness for detention and observed behaviour of detainees. What do you mean by that?
I think that an opinion provided by medical justice wasn't consistent with the opinion provided by the doctors.
Do you mean that from their behaviour detainees seemed well, but medical justice were reporting that they were unwell?
I'm not sure that it's about well and unwell, is it? I think it's about fitness to detain. Somebody may not be completely well, but they could still be perfectly fit to be detained, is my understanding.
You're not implying any level of dishonesty on the part of medical justice, are you?
No.
Or on the part of detainees?
No.
That they were seeking to misuse the system?
I think it's about perception, isn't it? When something you perceive to be a bad headache or a bad problem may not be perceived to be a bad problem by somebody else.
I see. I just want to ask you lastly a couple of questions about E-wing and the use of segregation. You said in paragraph 161 of your statement that E-wing and CSU were generally quieter due to having less people, and they were therefore better suited for those requiring constant watch due to suicide or self-harm risk. Did you understand that E-wing was used for segregating violent detainees or refractory detainees and those resisting their removal?
That was certainly part of Ewing, wasn't it?
The inquiries heard a considerable amount of evidence that Ewing wasn't a very quiet place. Why did you consider that it was, given you weren't there at the time?
I understand that the wider IRC was very busy and very noisy. Ewing was a much smaller facility with far less cells in it and far greater oversight from both the custodial services and the health services, and I believe that they also had better vision into the cells, such that it was a place that was better controlled, maybe not ideal, but probably the best option in the establishment as it was configured.
Did G4S Health Services give consideration at a policy level to the impact of segregation on a detainee with mental illness at the time?
I couldn't evidence whether they did or they didn't.
Does healthcare have a responsibility to assess the likely impact of being in CSU on a detained person so far as you are concerned?
I think that healthcare has got to be concerned, and medical professionals are, in my experience, extremely concerned about the well-being of individuals. I guess it's the choices that have to be made about what the best balanced options are in the environments in which they exist, and thus, although not ideal, my understanding is that the decisions were made on the basis that Ewing was a better option than leaving individuals out in the wider establishment, which could be noisy, busy, and not necessarily have the oversight that you would hope for the individual.
What was your understanding of the role of a GP in under Rules 40 and 42 in relation to removal from association and temporary confinement?
I'm not sure that GP had a role in Rule 40 and 42.
Well, Rule 47 says the manager may arrange at his discretion for such a detained person as aforesaid to resume association with other detained persons, and shall do so if in any case the medical practitioner so advises on medical grounds. That was a role of a GP, wasn't it?
Yes.
And under subsection 9, the manager, the medical practitioner, and at a contracted out detention centre, an officer of the Secretary of State shall visit all detained persons who have been removed from association at least once each day for so long as they remain so removed. So a medical practitioner had to visit every day if a person was on Rule 40. Again, that's a role particular to a GP in an IRC, isn't it?
Yes.
The purpose of those visits, and there's a similar provision under Rule 42, was to ensure the detained person's welfare, so a safeguarding role.
Yeah.
Would you agree? How was G4S Health Services senior management monitoring whether the GPs in Brook House were fulfilling that safeguarding of a detainee's welfare under those rules in 2017?
I don't know, however I do know there were daily meetings between healthcare and the doctors. I would have assumed it was covered in that.
Thank you. Yes, Chair, I have no further questions for this witness. Do you have any questions?
Thank you very much, Ms Simcock. I have no questions for you, Mr Dove. Thank you very much for coming to give your evidence today. I've
Thank you very
appreciated it. Thank you.
Chair, we're going to do a quick changeover given the time and that we've already had our afternoon break. So Mr Dove can step down and we'll proceed with the next witness, who is Luke Wells from
Thank you.
PQG.
repeat after me. I do solemnly, sincerely and truly
I do solemnly, sincerely and truly
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Please take a seat, Mr. Wells. Thank you.
Thank you. Can you give your full name to the inquiry, please?
It's Luke Andrew Wells.
Mr. Wells, you've made a statement for the purposes of the inquiry, which is at PPG 30169, and I'm going to ask that that statement is adduced in full. What that means is that I don't have to take you to every line of your statement or everything in it, but I'm going to ask you some questions about particular topics for your evidence on them. First of all, what is your role at PPG?
So I'm the Service Director for our Health and Justice Service line.
And what does that role entail?
Ultimately responsible for the operations of the services that we've got across England. So we run healthcare in 50 prisons and immigration removal centres, or places of secure environments.
Who do you report to?
I report to the Managing Director for our primary care business.
And he reports, I think, to the Chief Executive.
That's correct.
In the context of at the IRCs at Gatwick, you line manage, I think, the Regional Director for the South region of which that service forms a part. Is that right?
That's correct.
You say that you've worked in the health and justice sector since 2007 and have held a number of management and leadership roles during this time. Just very briefly, what type of roles have you had over that period of time?
So all operational roles, so heading up services, regional management roles, regional director role, and more latterly, my current role as Service Director.
You say that you joined PPG in June 2016 and you commenced in your current role in January 2021, is that right?
That's correct.
Can you just briefly explain what PPG as a company's experience is of working in IRCs as opposed to prisons?
Yes, so we've had some previous experience of working within immigration removal centres. They're not particularly services that I've personally been involved in before, but I believe the Verne was previously an immigration removal centre before it became a prison, and Campsfield House, I think, was another.
Thank you. As you say, you have, as a company, a greater experience previously in relation to healthcare in prisons, is that right?
That's correct.
Would you accept that an IRC operates a different detention environment to a prison because detainees in an IRC are not there by order of a court, but rather because of an administrative power being exercised by the Home Office?
Yeah, that's correct. There are obviously some similarities between the two environments, but they do serve a different purpose, yes.
And of course, there's no time limit to immigration detention in contrast to that in prisons. Is that right?
In most instances, yeah.
So the role of healthcare in an IRC is therefore not just to provide primary healthcare to detainees, but also to provide important clinical safeguards which identify who is vulnerable to harm in detention and to notify the Home Office of those people so that their continued detention can be promptly reviewed and that they might be removed from detention. Is that right?
That's correct.
You, in terms of the company, were reliant upon the existing healthcare staff transferring over from G4S Health Services to PPG when you took over the contract in relation to Brook House. Is that right?
So for staff that are specifically delivering service on the ground, yes, largely that's the case, supported by a team of bank and agency staff as well.
At paragraph 9 of your witness statement, you say that the most senior individual employed by PPG based at the IRC in Gatwick is the head of healthcare, who is also the CQC registered manager responsible for the service. This individual holds primary responsibility for the running of the service and partnership working with the operator and the Home Office, taking the lead on local meetings and daily briefings. Is that right?
Yeah.
And that was, as it was in 2017, that is now Sandra Calver. Is that right?
Yes.
And so she holds primary responsibility for making sure that PPG complies with the safeguards required to be operated in Brook House. Is that right?
Yeah, not in isolation, so there's obviously a team that support her with that, but yes, primarily speaking on a day-to-day basis, that would be Sandra.
In relation to the GPs, Dr. PA, who PPG subcontracts to provide primary care services, those are the same now as they were in 2017, Dr. Uzerali and Dr. Chowdhury, is that right?
That's correct. They only provide the GP part of the primary care service, though. The rest of it will be provided directly by our employed nurses.
And you say in your statements that you're transitioning away from subcontracting to Dr. PA Limited to a mixture of both subcontracted and employed doctors. Is that right?
Yeah, so I think the intention is to take a phased approach to this, whereby we would over time reduce the involvement of Dr. PA within these services with an aim to eventually run the service with full-time employed GPs.
But at the moment, they're still the subcontracted GP service, is that right?
That's correct.
And as you say, you'll take a phased approach to, first of all, employing some GPs, but also subcontracting to them.
Yeah, that's correct.
Just pausing there for a moment, what are the reasons for moving towards employing GPs directly rather than subcontracting that service? What are the benefits to doing that?
So I think organisationally that's always our preference. I think we tend to find that GPs that we employ directly can at times be more engaged with services. They certainly feel more embedded at times with the team. I also think it helps us in terms of supporting their professional development. We invest quite heavily in our GP workforce. So when it comes to things like training, it offers us greater flexibility to support them with that.
I see. But currently, at any rate, and for the immediate foreseeable future, the current arrangements for healthcare provision by PPG have been informed by both Sandra Calver as Head of Healthcare and by Drs Uzerali and Chowdhury as Dr. PA Limited. Is that right?
Yeah.
The inquiry has heard evidence from the three of them. Did you hear their evidence?
So I've heard Sandra Calver's evidence. I didn't hear either of the GP evidence.
Why not?
Largely because when we originally were invited to give evidence, we decided to split down our evidence. So I'm here from more of an operational perspective. My colleague, Dr. Sarah Bromley, is here from a medical perspective. So it felt more suitable that we divvy out the evidence, or observing the evidence.
So if there are points that come directly out of their evidence that you can't answer, then she'll be able to answer those for us.
Hopefully so, yes.
Given you heard the evidence of Sandra Calver, does her evidence cause you any concern on the part of PPG about her continuation as Head of Healthcare at all?
No, I think it's clear from Sandra Calver's evidence that there is some work that needs to be done, certainly around things such as Rule 35. However, as an individual, I believe Sandra Calver is a registered clinician. We've had no concerns in terms of her professional practice. She appears, from what we've known of her for a very short period of time, to be quite caring and compassionate, and seeks to do the right thing in the interest of our patient group.
So you have confidence in her to fulfil her obligations and responsibilities in relation to her role in Brook House?
Yeah, I think obviously with training and support, for additional training and support from the wider PPG organisation. So let's look at, please, then rules 34 and 35 of the detention centre rules. Are you aware of the content of those rules? Yes.
Rule 34 requires a physical and mental examination used to identify vulnerabilities in detainees, and it could and should result in a Rule 35 report where appropriate, so that the Home Office is notified promptly at the outset of detention of those vulnerabilities and that detained person's detention reviewed. Is that your understanding of the rule?
Correct.
And that's particularly important as a rule because the Home Office doesn't have any pre-detention medical screening tool to identify vulnerabilities before detaining a detained person. Would you agree with that?
Largely speaking, the Home Office may not. We may sometimes have prior information based on, depending where the detainees come from. So, for example, if they're transferred from prison, their prison healthcare records would transfer with them. So we may have more background information than the Home Office would.
And that information would help to inform you in the Rule 34 process of vulnerabilities as being the first opportunity for assessing those vulnerabilities in immigration detention. Is that right?
Yes, that information will be readily available to the GPs undertaking those assessments and the nurses who do the initial screening.
And so as a rule, it's therefore vital in functioning effectively so that people particularly at risk of being harmed in detention can be identified and removed from detention where appropriate at the outset, at that first arrival into detention. Is that your understanding?
I think that's the intention. What I would say is I think the notion that to carry out an assessment on somebody within their first 24 hours when they're likely to be very vulnerable, very emotional, and have a lack of trust really in people of authority, I would suggest that that's quite a difficult assessment to do in such an early point at which somebody's been detained. But yes, I understand that's the purpose, and that was the thinking behind the rule being written.
Yes. You'll be aware from listening to Sandra Calver's evidence, but we heard from her that the GP appointments carried out within the first 24 hours were at the time 5 minutes long, are now 10 minutes long, and that really isn't enough time to do a fully compliant Rule 34 medical examination, which requires a full physical and mental examination. Would you agree with that?
I think it's a very difficult question to fully answer. I think the wording of the rule is not very specific around the extent to which an assessment is required. So, for example, for a mental health assessment, that could involve a whole hour's appointment with a psychiatrist, for example. That's one extreme. So I think it's unclear, and I think it's fair to have heard evidence over the last few days to suggest that there is a bit of a lack of understanding around the purpose of Rule 34.
Dr. Uzarali also said in his evidence that it wasn't possible to do the sort of physical and mental state examination required at that initial GP appointment, and he described it as being really only triage. Would you agree with that?
Yes, I would.
He gave evidence that if there had been a disclosure, for example, of torture in that initial appointment or something else raised, which meant there should be consideration of a Rule 35 report, instead of completing a report immediately, which he wasn't doing and indeed isn't doing, a further longer appointment was made sometimes sometime later, and that built in some delay. Would you agree that that's the practice even now in Brook House in relation to that initial Rule 34 and then further Rule 35 assessment?
Yes, that's correct.
So, given the importance that you've agreed of the Rule 34 examination in leading to a Rule 35 report where appropriate, in that it's to screen people out of detention by notifying them to the Home Office of their vulnerability, why is it that there is insufficient provision made to ensure that Rule 34 can be properly complied with, so that a Rule 35 report can be done immediately as a result of that appointment?
So I think our understanding previously would have been that the spirit of Rule 34 was around identifying immediate risk and then ensuring that there's follow-up action to be taken. I think when you consider the evidence of Dr. Hard, whereby he stated that these would need to be significant longer appointments, at the moment within the service, we would not have the capacity to do that to any great extent. So I think operationally we're trying to make the best we can of the safeguards we've got within the resources available to us.
Those initial appointments, as Dr. Uzarali confirmed in his evidence, are clearly not leading to Rule 35 reports directly as a result of those first appointments. Do you accept that at least one reason for that is that they're so short? It's simply not possible to complete the examination and a report within a 10-minute appointment.
I'm not sure I completely agree with that. I think for me there's clearly learning to be done around Rule 35, and I think with better education and understanding around Rule 35, whilst the current process may not be ideal, would still serve a purpose given as I've already said, the context of the resources available to us and the volume of patients that we would be required to see.
But it does build in delay, doesn't it? The Home Office certainly aren't being informed at the outset of detention about these people. They're continuing to be detained because their detention isn't being reviewed. There are effectively delays built in to those arrangements, aren't there?
Yeah, so a follow-up Rule 35 appointment will be roughly 2 days, so I accept that creates an element of delay. But as I mentioned before, I think to some degree there is also some benefit in having a slight time lag between people arriving and that assessment taking place if need to be, because it allows you to try and build up a greater level of trust with the individual, so you get a more open and honest and transparent consultation.
That might occur in some cases, but there's at least also the possibility, isn't there, as the rules are designed to prevent, that someone remains in detention and deteriorates during that time, isn't there?
Yeah, that's absolutely possible, and there are other safeguards in place to try and identify those individuals and make sure we manage them as best we can within the constraints of the service.
So it's still a case of trying to manage those people in detention as opposed to using the statutory mechanism to have their detention reviewed by the Home Office. Is that right?
Yeah, I think it's around the delivery of healthcare rather than just the Home Office process, that's correct.
Is the Home Office aware from PPG that only 10 minutes are allocated to those Rule 34 appointments?
I could neither confirm nor deny what they are or are not aware of. My understanding is they're very closely involved with the service, so I'd be very surprised if they didn't, but that would probably need to be a question for the Home Office.
Well, have you raised with them that those appointments are only 10 minutes and therefore can't comply with the Rule 34 full mental and physical examination, potentially leading to a Rule 35 report?
No, I personally haven't, no.
Have they ever raised any concerns with you or PPG, to your knowledge, about the length or the provision generally of those appointments?
I don't believe so, no.
Are you taking any steps to allow for more time to be afforded to those initial appointments?
So we're currently in the process of undertaking a review of our pathway for Rule 35. So that's a piece of work that will take place in April, and obviously from that we'll make decisions around what we need to do. If we need to extend those appointments, then that may need to be conversations that we have with NHS England as our commissioning body.
Yes, so because PPG subcontracts the GP services to Dr. PA Limited, so it would be within PPG's power to obtain more resources from them in terms of either the time the GPs who are there are using to undertake those appointments, or to require more GPs to carry out the service.
So I believe there is scope within the contract for us to negotiate around the amount of time that the doctors would spend on site, yes.
Has there been any review of the contract in order to make compliance with Rule 35 and 34 something that's front and centre in the contract in terms of being a KPI, or having penalties applied if those rules aren't complied with?
So at this stage, no. We're seeking to engage with Dr. PA. So as I said, there's a workshop that Dr. Bromley will be chairing in April. Dr. PA have been invited to attend that. So we'd like to use some of their knowledge as well in terms of informing our pathway and our processes to be able to develop a PPG, I suppose, operating procedure really around Rule 34 and Rule 35. Once that piece of work's been conducted, then if needs be, we can review the contract with Dr. PA, yes. But I think we would seek to work in the spirit of partnership with them and try and work and educate them rather than impose financial penalties.
Has there been any, or is there intended to be any review as to whether Dr. PA Limited, in the form of Dr. Zuzarali and Dr. Chowdhury, should retain the contract and should continue to be working at Brook House at all?
At this stage, no. So, as I said, we would seek to work with the doctors involved. I think it's fair to say, as I said, there has been quite widespread misunderstanding, shall we say, around the application of those particular rules. And therefore, I think we need to seek and clarify a PPG position first, and then have very clear expectations with the doctors that work within the service that they would be expected to follow those processes.
You mentioned that that there's going to be a phasing out of the subcontracting services. In relation to the individuals, though, Dr. Uzarali and Dr. Chowdhury, is there consideration being given to employing them directly at PPG in the future in Brook House?
So my understanding is that we would have explored that option with both GPs prior to the service go live. I don't believe that was something that they were keen to explore further with us.
I see. In relation to Rule 35, Sandra Calver accepted in her evidence that in 2017 she had a misunderstanding of the thresholds to be applied under Rules 35.1 and Rule 35.2, and that she was applying too high a threshold. She gave some evidence that she had thought that a Rule 35.2 report was a report stating a detainee was severely suicidal and not suitable for detention. And she accepted that threshold could be risky and potentially dangerous and wasn't in accordance with the rule. Were you aware of that?
Of her evidence, yes.
She also thought that a Rule 35.1 report was a report stating a detainee had a severe or unstable medical condition, which meant they were not suitable for detention. And she gave evidence that she and indeed her staff didn't have a good understanding of Rule 35.1 and 2, and that was a significant gap in knowledge both then in 2017 and now. Were you aware of that?
Well, I was at the point at which that evidence was given. I wasn't aware of that previously.
That's a concern, isn't it, if it's still a continuing situation?
Yeah, and as I said, that's why we've put in place plans to mitigate that risk. So organisationally, we want to take an organisational position rather than this be based on the experience of one or two individuals. I think, as I said, it does appear from having conversations with Sandra and other IRC heads of healthcare that there is a broad lack of understanding around this. So I think we would also be seeking to work with the Home Office to understand what their expectations are.
She, in circumstances where Rule 35.2 reports weren't being completed in Brook House, she drafted the G4S pathway for Rule 35.2 that didn't meet the technical requirements of Rule 35.2 because it built in an extra step of a nurse and a delay. That pathway, we understand from PPG's witness statement evidence, is still in place in Brook House. Does that concern you?
Yeah, it is of concern, but I think it's also important to set the context for this service. So, as you know, this service went live with PPG on the 1st of September. The service has been declared an outbreak by the UK HSA throughout that period of time, which means our ability to access the site has somewhat been limited. It also means that, unfortunately, staff have had to take up some extra responsibilities caring for those patients who are COVID positive and the extra monitoring involved and plus the mass testing event. So I think this is not probably our standard approach to mobilisation, I would suggest. So I would have expected us to have been working through some of these issues earlier than we are at the moment. But I think nonetheless, as I said, we do have plans in place to work to address this.
And so
I also think, that the priority was also around ensuring that we enhance the service offering as well. So Dr. Hard gave some evidence, didn't he, around the conflict to some extent between delivering healthcare and managing some of those processes. And I think organisationally, probably our focus was on looking at the healthcare side and improving, the offering in terms of things like mental health and additional ancillary services.
do you accept that the clinical safeguards that operate under the rules are as, if not more important than the provision of primary healthcare in an IRC because of their role in safeguarding vulnerable detainees by rooting them out of detention where they're likely to be harmed by detention?
So I wouldn't say they're more important, because I think if you're running a service that purely only manages risk and isn't effectively treating people, then it's reasonable to assume that people will deteriorate. Therefore, that's not good for their health either. So I think both need to be taken in equal measure.
What action does PPG intend to take, in particular, in relation to the Rule 35.2 pathway drafted by Sandra Calver?
So the purpose of the workshop is to agree what our pathways will be going forward. So a new policy will be written around that. That will be a national policy. We will expect the service at Gatwick to be complying with that policy.
Well, is there a need for a pathway when the rules are clear themselves? The rules require notification under the three different limbs when the threshold is met.
So yes, I think there is a need for a pathway, and the reason for that is that Rule 35, the process itself is probably more simple, but actually, as we've heard in evidence, it requires staff identifying patients and making the GPs aware of them. So this is not just about a simple process with the Home Office. It's about trying to change a culture and change the attitude and beliefs of the people that work in the wider service.
Sandra Calver accepted that there was a failing in relation to the safeguards in two different respects. Firstly, that nurses clearly were applying the too high a threshold that she accepted, so that they weren't referring detainees to the GPs when for consideration of Rule 35(1) and 2 reports. She also said that even when referred or when GPs were seeing patients and the threshold was met, the GPs simply weren't completing Rule 35(1) reports, or only on very rare occasions, or Rule 35(2) reports we know at all, in 2017 and indeed since. She had tried to ensure with the GPs that they were completing Rule 35(2) reports, partly through the pathway, but they simply weren't. We know from your colleague Sarah Bromley's statement that Rule 35(2)s are still not being done, and there are very few Rule 35(1)s, only one from September 2021 to January 2022. So this failure in the safeguards remains a significant concern at present, doesn't it?
I would agree, yes.
You've talked about developing the pathways in order and liaising with the Home Office in order to address this issue. Is there anything else that PPG is doing to ensure that reports are being completed when they should be under the rules, in circumstances where even up to January of this year they're not being?
So I think once the pathway is agreed and is formalised, and we're not a particularly bureaucratic organisation, so that shouldn't take a significant amount of time. I'm quite confident after the workshop's held that can be written up. The expectation would be that will be audited so that we can ensure compliance.
And audited how and by who?
So primarily audits will be undertaken by the site, but I think given the significance of the Rule 35 and the level of scrutiny it's come under, then it may well be that we decide to audit that at a regional level with the regional medical lead, who is the GP responsible for GP services within that region.
In paragraph 15 of your first witness statement, you say that provision is made for 2 Rule 35 appointments per day, and that's over and above the provision that PPG has made for primary care services. Do you consider that to be sufficient provision?
I think that decision has been based on the previous ways of working and interpreting those rules. It may well be that we do need to review that following the outcome of the workshop and understand what provision needs to be ring-fenced for
Yes.
Rule 35.
Because it doesn't take account, does it, that every detainee should have a Rule 34 appointment of a physical and mental examination within 24 hours of arrival, which could and should, if appropriate, lead to a Rule 35 report?
Yes, so the Rule 34 appointments will be separate to that. So that's not included within those appointments.
So what provision is there going to be for Rule 34 appointments that could and should lead to a Rule 35 report, if appropriate?
So Rule 34s are seen currently within the 24 hours.
But again, is the intention still only to afford every detainee a 10-minute appointment going forward?
I think we need to seek further clarity from the Home Office before making a commitment around what level of resource that would require.
Because that's not enough time, is it, to complete a Rule 35 report, if appropriate? It still would build in the delay for a further longer appointment to be booked at a later date within those 2 appointments per day.
Yeah, I think the challenge is what's practical as well. So obviously not every patient that is reviewed under Rule 34 will need a Rule 35. Therefore, it's an ineffective use of a GP's time for a Rule 30 or an appointment length that would facilitate a Rule 35 appointment to be offered to every single individual. And that's I think the balance that we're trying to understand and work through.
Would you agree that a high proportion of detainees in immigration detention have clinically significant levels of depression, PTSD and anxiety, as Dr. Bingham gave evidence
Yes.
And are you aware that PTSD is frequently linked with a history of torture or other forms of serious ill treatment?
Yes, I am, yeah.
Would you agree that detention is likely to precipitate significant deterioration of mental health in the majority of cases?
I'd have to be led by experts in that area, but it seems reasonable to me that detention could pose as a trigger for patients who have a diagnosis of PTSD, yes.
And that detention can also, for example, increase self-harm and suicidal ideation.
Yes.
Given the high prevalence of people with PTSD and of people who are likely to have a history of torture and who are therefore likely to be harmed in detention, their prompt identification to the Home Office is essential.
Yes, would agree.
Because prompt identification can lead to Rule 35, which may lead to their release from detention.
Yes.
Dr. Uzarali gave some evidence that there are currently delays in getting through the number of Rule 35 reports that need to be done, and there's a waiting list. He said that there was only one Rule 35 appointment a day. Can you account for the discrepancy between that evidence and the two appointments you say are available a day?
So in preparing my evidence, I consulted Sandra Calver, who's the head of healthcare and responsible for that service, and the regional manager. They were very clear with me that it was 2 appointments a day. However, I'm very happy to go back and investigate that further and report back to the inquiry.
Thank you. Would you accept, though, that whether it's 1 or 2 appointments a day, given the prevalence of the conditions we've just talked about and their link with vulnerabilities and therefore the necessity for the safeguards to apply, that's likely to be inadequate provision going forwards in terms of Rule 35 appointments?
Yes, as we've discussed, there's certain elements of the Rule 35 that appear to be non-compliant at this moment in time. Therefore, that may increase demand for that particular part of the service.
Yes. Were you aware of the IMB report of 2021 that reported on the year from January 2020 to December 2020?
I have seen that report, yes.
Appreciating that was before PPG took over the contract, because you started, as you said, in September 2021. It would have been important for PPG to understand what the situation had been in the period prior to taking over, wouldn't it?
Yes.
That report described the lack of any Rule 35-2 reports to be puzzling in the light of the scale of self-harm and suicide threats made during the latter part of 2020, when there were compressed charter flights. And the IMB said we cannot reconcile the evidence of frequent suicidal ideation with there being absolutely no Rule 35-2 reports. You'd agree that's of significant concern?
I would agree it's of significant concern, yes. I don't believe that IMB report was made available to us as part of the tendering process, though. So normally you would receive a health needs analysis that's commissioned by NHS England that would indicate the current level of provision and gaps in service provision. I can't absolutely categorically state, but from memory I don't recall any documentation to suggest that that provision was inadequate at the point at which we were tendering for the service.
Yeah. PPG's statistics on ACDTs indicate that 73 were opened, with 45 on a constant watch for the period of September 2021 to December 2021. So that's since PPG took over. Were you aware of that?
I wasn't aware of that, no.
Would you accept, as Sandra Calver did, that someone being on a constant watch indicates that they're at a high risk of suicide?
Absolutely, yes.
There clearly still were no Rule 35-2 reports in that period, so in the period from September 2021 to December 2021, despite the 45 constant watch ACDTs. Dr. Uzarali, as I've mentioned, gave evidence that he's still not completing Rule 35-2 reports, and he gave evidence now over 2 weeks ago. Has PPG taken any steps immediately to address that discrepancy?
No, I think we took a conscious decision that we wanted to ensure that we had a full and robust process and policy in place, rather than just make an immediate snap decision to put something right. As I've said, I think this is about a whole system approach review, rather than just putting in place, for want of a better phrase, a sticking plaster over an issue.
But isn't the risk of that, though, Mr. Wells, that detainees are remaining in detention with suicidal ideation, meaning the threshold for a Rule 35(2) report has been reached but hasn't been completed, exposing them to a risk of further harm in detention because their case hasn't been notified and therefore reviewed by the Home Office?
Yeah, I accept that. And I think, as I said, the lack of Rule 35 doesn't necessarily mean that they're not receiving any healthcare provision or any treatment. But in terms of their detention or their potential release from detention, that is currently a gap that we're seeking to address.
At paragraph 32 of your witness statement, you say, due to the nature of how IRCs operate, high volumes of patients arriving at once, especially during the night, can place a strain on staffing levels. However, we have in place appropriate mechanisms to support our staff during such peak periods of demand by utilising a shortened version of the initial reception screen. Again, in relation to that, isn't there a greater risk that that will contribute to further delays in identifying vulnerabilities?
No, I don't believe so. I think there's a couple of observations on that particular point. So firstly, since we took over the service, we've actually increased the staffing on a night from that of the previous profile. So we've got an additional nurse that works over at Tinsley House. So I think largely speaking, the Rule 34 nurse assessment would be done still within a couple of hours, but it may not meet the initial 2-hour threshold, which is why we'd want to do an immediate safety risk to ensure that patients are as safe as they can be in the interim.
The IMB in their 2021 report also said that in September the board asked the Home Office if there would be provision for extra mental health resource which could allow focus on preventative measures to alleviate stress and anxiety. The response, in other words from the Home Office, was that healthcare staff had not requested any additional resource. Does your existing contract allow you to ask for more resources if you need them?
So we can ask for more resources if we need them, yes. That would be via NHS England rather than the Home Office, because they're responsible for commissioning and funding the provision of healthcare. What I would say is that I think our model is different from the model that was previously on offer under the previous provider. And I think we've already built into that an element of delivering proactive mental health care. So things, for example, such as talking therapies, our Making Sense programme, which is a trauma-informed programme aimed to support people with low-level anxiety, managing low-level mental health conditions. So I think we've already made provision for that within our existing contract. But if we felt that that was not sufficient, then we would engage in a conversation with NHS England to explore that further.
What about exploring further resource for the Rule 34 and 35 appointments in circumstances where reports still aren't being completed under two limbs of the rule, in circumstances where there are high levels of self-harm and suicidal ideation?
So that may well be a route that we need to take. I think obviously we are conscious of use of the public purse, and we'd look to seek to understand what else we could do to redesign our services to accommodate that. So for example, I do believe that there is more that the nursing team could do to take some of the workload away from the GPs. We also have a nurse that's undergoing advanced clinical practice, so we'll be able to deliver a significant chunk of what currently sits with the GP. So it may be that we can reconfigure some of our existing services, but if we reach the point whereby the service is no longer tenable in that regard, then we would be having conversations with NHS England about that.
And I appreciate freeing up GP time by transferring some duties to nurses may assist in the GPs doing Rule 34 and Rule 35 appointments, but nurses certainly can't take that responsibility under the rules, can they?
No, currently. So that would still have to be done by the GP. It's more around the delivery of what we would call routine healthcare or primary healthcare.
The period that the IMB was reporting on in their 2021 report was at a time when there were substantially fewer detained people at Brook House. In quarter 3 in 2020 there were 339 detained persons, and in quarter 4 254, whereas in 2021 in the same period there were 574 and 464 detainees respectively. Again, the problems are likely to be compounded, aren't they, with greater numbers of detained people in Brook House?
Yeah, absolutely. That's common sense, really. I think what I would say is our experience of the service thus far has been on a significantly lower operational, not capacity, I can't think of the word I'm looking for, but the role in essence has been lower. Therefore, that's been our experiences thus far, but we're very adept to changing services when the need arises. So, for example, if a change of purpose in some of our prisons, for example, where courts have been closed and we've had to take significantly more new arrivals, we have the ability to amend our services at relatively short notice.
And so is that also a consideration that PPG are planning to review the allocation of resources to the Rule 35 process, given an uptake in the number of detainees?
Yeah, so as part of our modelling, I think as I said, I think we need to understand the process that we're endorsing first of all, in conjunction with the Home Office, and then we would need to look at what level of resource would be needed to meet the service demand in that area, both now and as the service continues to grow.
The IMB also noted that there were examples in 2020 of removals whilst detainees were in a state of distress or injury following self-harm, which the IMB called inhumane and put detainees at further risk. And they also criticised the absence of any arrangements for briefings from healthcare to the Home Office about those most vulnerable detainees. Were you aware of that in that report?
I had seen it in that report. I wasn't aware of it being an issue prior.
Are there now arrangements for such briefings from healthcare to the Home Office about those type of vulnerable detainees?
I can't answer, unfortunately. I'm not sure. Again, I'd be happy to report back to the inquiry on that particular matter. I only received the IMB report quite recently, so I've not had a chance to explore that further.
Yeah, we'd be very grateful. In relation to use of force, the IMB report also expressed concerns about the high incidence of use of force being used to deal with incidents of self-harm. Were you aware of that?
Yes.
And they also noted proportionately large numbers of the use of Rule 40 and constant watch to manage vulnerable detainees. Were you aware of that?
Yes.
Sandra Calver confirmed in her evidence that use of force is still used for relocation of detainees to E-wing, and segregation is still used for managing mental health issues, suicide risk, and for detainees on a constant watch. And there's no clinical risk assessment for those not going to the CSU but going to segregation on E-wing. Are those matters for concern for PPG?
They are, yes. I think they warrant further exploration, yes.
Are use of force risks exacerbating and damaging further the mental health of a vulnerable detainee? Do you agree that use of force shouldn't be occurring in relation to vulnerable detainees unless it is immediately to prevent a risk to life?
I think if it's a planned use of force, then there should be a discussion that's held in conjunction with healthcare so that the centre management can make a decision as to the appropriate way forward with our advice. I don't think it can be categorically ruled out, but I think certainly generally our advice would be that it should be avoided wherever possible.
It's certainly a last resort.
Yes, I would agree, as a last resort.
It's a concern if it's still being used as a custodial risk management tool to respond to incidents of self-harm, isn't it?
It is of concern. I can see to some extent why there is a challenge to the officers that are responding to these incidents, in that often they may be with good intent trying to preserve life, but I accept that there's got to be a balance between that and weighing up the impact on a detainee's mental health.
Because the risk, of course, is that deficiencies in the safeguards, meaning vulnerable people aren't rooted out of detention but remain in detention being managed, and the use of force and segregation in this way as a risk management tool risks another situation like there was in late 2020, where the whole detainee population, the IMB found, were subject to inhumane treatment. Would you agree?
Sorry, can you just repeat that question for me again?
So the danger is, the risk is that where there are deficiencies in the safeguards, so people are being managed in detention and not rooted out of detention because of delays in the Rule 34 and 35 process, and where there is use of force and segregation to manage incidents of self-harm, there risks a situation like there was in late 2020, which the IMB described as subjecting the whole detainee population to inhumane treatment?
So I think I go back to my earlier comment really around Rule 35. So accepting that there is an element of non-compliance with Rule 35, and that does present a risk. I still think that there are safeguards in place, i.e. we understand these patients, we understand their needs, and therefore we should still be in a position to advise detention officers on the appropriate use of force.
That situation that the IMB found that Brook House wasn't a safe place for vulnerable detainees and that the circumstances there amounted to inhumane treatment of the whole detainee population happened under the watch of Sandra Calver as head of healthcare and of the doctors that you subcontract to currently. Isn't that of concern to you?
So yeah, I think it is. I think what I would say is inhumane is subjective. I do believe that an immigration removal centre is probably not the right location for certain vulnerable individuals in general. So I don't believe these people should be there to start with. I'm not sure quite how much of that realistically is within our gift to manage. Accepting that, I think there is more work that we can do in that regard.
In particular, in relation to Rule 34 and 35.
Correct.
The IMB recommended a systematic and ongoing review of vulnerable detainees to monitor the effect of continued detention on their well-being. Dr. Hard gave some evidence that it was his opinion that there was a need for such a system of ongoing review of vulnerable detainees in detention. Has there been the introduction of a systematic and ongoing review of vulnerable detainees in detention?
So vulnerable individuals would be reviewed as part of the delivery of healthcare services. So, for example, those with severe mental health would be assigned a caseworker within the mental health team that would meet with the individual regularly, and obviously as part of their assessment would understand if people were deteriorating. I accept the fact that what I don't believe is happening is that is triggering a further Rule 35 review in most cases at least.
So does PPG plan to address that gap?
Yes, so as part of the Rule 35 pathway review, that will also consider what work needs to be done to understand there are regular follow-ups or reviews. I think there are already processes in place to flag whereby we have concerns around an individual. We run multi-professional complex case conferences on a weekly basis. Those kinds of things could be discussed there, but also we've got things like a duty mental health worker who could flag any immediate concerns and bring those to the attention of the head of healthcare and, if necessary, the GPs.
Yeah. Did you watch the Panorama programme?
I did watch it, yes.
You're aware then of the involvement of some healthcare staff in making derogatory and mocking comments about detainees. You'd presumably agree that those types of comments have no place from healthcare staff in an IRC.
I agree with that question.
And with Sandra Calver that they're completely inappropriate and would be of concern if you were aware of them.
That's correct.
Does it concern you that at the time as head of healthcare she was unaware of them?
So I think it's a difficult question to answer in some ways. Can we hold an individual, even though they are the head of health, are responsible for the actions of individuals? Some would argue yes, some perhaps no. I think that the reality is that I think in evidence Sandra Calver said she was very surprised about that. It is a very small team who work in a very small and confined environment, and by virtue of the fact it's a secure environment, that means that people are pretty much on top of each other, if I'm honest. So I would have been very surprised, having got to know Sandra a little bit since she's joined the organisation, if she had any concerns or suspicions that the behaviour of staff was not in line with what she would expect, that she wouldn't have addressed that.
Yes. What steps have or are PPG taking with regard to ensuring a culture of dehumanising and degrading detainees doesn't persist in Brook House?
There's a couple of things really. I think firstly we are very keen on ensuring that clinical supervision is embedded with our clinical team. That's not just to review incidents, it's about talking around reflective practice, having discussions around things like compassion fatigue, and really having a safe space for people to be very honest about some of the things that they're struggling with and the challenges that they have. I think on a broader scale we are currently working with an external organisation to look at how we better embed trauma-informed care within that service, and there are four 4 themes to that, really. One is around a general level of training that you would expect anybody to have. If I'm honest, even the detention custody officers, we're very happy to open up that training to them. That's around basic awareness of trauma-informed, looking at things like adverse childhood experiences, those kinds of things. The second is around a more detailed training that is given to healthcare professionals so they can understand or better identify signs of trauma, but also working within the course of their general duties, be able to assess for trauma. So that's another point. I think there are some bigger ambitions that we have, but that will require further work with Serco as the operator for us to implement. So that will be around the leadership team unitedly challenging things like language and behaviours. And then the fourth element, which is quite aspirational, but nonetheless is one that we want to pursue, is around understanding what elements of detention can re-trigger people around their trauma and trying to avoid those. So it's a 4-pronged approach that we're looking to develop to try and prevent the exact scenario that you would have seen on the Panorama documentary.
I just want to finally then ask you about some of Dr. Hard's recommendations, particularly in relation to training and various aspects. Would you agree with him that better training is needed for both detention and healthcare staff in the use of force?
Yeah, absolutely. In fact, we've also taken steps to address that ourselves. So for the last year, because use of force is equally used within our prison establishment, so the principles are exactly the same. So we've been working with there is no off-the-shelf training, it's very clear. So we've been working with our Director of Nursing, consulting with colleagues who offer things like CNR training, for example. So nurses are absolutely clear what their role is within any use of force. And that's been rolled out across our whole organisation. I think it's just about to commence in a site and will be on a phased rollout.
Yes, because it's clear they didn't understand that in 2017. Would you agree?
Either didn't understand it or chose not to enforce their role, yeah.
And appreciating that force is of course used sometimes in prisons, the difference in the population is that you have a particularly vulnerable population in IRCs in terms of underlying mental ill health or experiences of trauma, particularly in relation to being victims of torture. Would you agree?
I don't think it's always unique. So, for example, H&P Huntercombe, which is a prison, is used to house foreign nationals. So I think there are definitely some transferable skills within the prison estate that we can bring to the immigration removal centre setting.
But those aspects of the population certainly need to be particularly considered in relation to training, in relation to use of force. Would you agree?
So every prison is unique, or every immigration removal centre is unique, and it needs to cater for the needs of the people that are detained there.
Would you agree with Dr. Hard that there needs to be better training in relation to healthcare's role in the ACDT process, and in particular that there needs to be some understanding of the link between those who are on ACDTs and the safeguards under Rule 35 applying?
So I don't necessarily agree that there needs to be further ACDC training. My understanding is that that's an annual training programme that is delivered by Serco, who are the operator, and the feedback is that generally appears to be very good and comprehensive. I think the issue is around the link to Rule 35, and it's really training around Rule 35 that we need to resolve.
That would address that link?
Yes.
Including in relation to food and fluid refusal and the link between those who refuse food and fluids and potentially the applying of the safeguards under Rule 35?
Yes.
Would you agree with him that training ought to be provided aimed at addressing compassion fatigue and desensitisation of staff as to what they encounter at Brook House?
Yes, as I've already said, I think that will be included in the trauma-informed training that we're looking to roll out.
And you've already addressed that there should be better training in relation to Rule 35, as Dr. Hard also agrees. Do you consider that it's PPG who should be supplying that training, or some other organisation?
I think it's a joint responsibility. I think it's really evident that there is a lack of clarity around Rule 35. Therefore, my view is that there should be some training that is delivered by the Home Office, as it's a Home Office policy or ruling, but that equally should then be followed up. As I said, it's not just around the process for Rule 35, it's a whole system approach around the identification of people and the pathway then that those people need to go through in order to get their appropriate assessment. So I think it's a joint responsibility, and it has two elements to it.
Thank you. Chair, those are all the questions that I have for this witness. Do you have any questions?
Thank you, Ms Simcoe. I do have a couple of questions for you, Mr Wells. Thank you. I wonder if you could tell me a little about the timeframes for the review of the pathway, the Rule 35 pathway that you're undertaking.
When you say
The timeframe. So, when did you start it? When will it be concluded?
so it's commencing on the 20th of April.
The 20th of April.
Yeah.
And when is it due to conclude?
So we haven't got. Obviously, it depends what falls out of that event. As I said, we're not particularly bureaucratic, so I would hope that we would have a better informed policy at least within a few weeks of that taking place. Obviously, depending on what the findings are from that particular piece of work, if that does involve service redesign or conversations with our commissioners, then that could extend that period. So it's a little difficult to give you a definitive, but I would expect at least that we would have a policy on it by the end of the month.
End of
April, sorry.
End of April. Okay, thank you. You, in response to one of the questions that Ms Simcock asked you around the 10-minute appointment that is currently being offered, you said that you would need to seek further clarity from the Home Office before making a commitment around the level of resource that might be required to offer more than a 10-minute appointment. Do you intend to have that conversation with the Home Office? Yeah,
absolutely. So my understanding is the Home Office have already suggested locally to Brook House that there needs to be some form of either further training or review of that. So I would suspect that that's a good forum with which we could explore further discussion around what exactly is involved, or what is their understanding of what exactly is involved by the term assessment within that ruling.
Okay, thank you. And then finally, again, Ms Simcock asked you some questions around this, the discrepancy in the numbers of people on constant watches towards the end of 2021, in contrast to the lack of Rule 35.2 reports. And obviously I understand from what you've told us about some of the reviews that you're going to be commencing and looking at that as an issue. And your answer to Ms Simcock was that you didn't want to make any immediate snap decisions around that. Have you given any consideration to the potential issue that there are people now in detention currently who are not going to be being referred for Rule 35.2 reports where there has been suicidal ideation expressed?
Yeah, I think so. I've discussed that with Dr. Bromley. I think our view is clear. Whilst we accept that there is an element of risk within that, I think there's also an element of risk in terms of bringing in a series of changes to working practice, which can be confusing to staff. And given that this is a long-standing issue, it's not a new issue that's been operating for some time, I personally am in favour of an approach whereby we take a very clear approach. Whilst that will involve, roughly a 3-4 week wait, I think it's a much better way forward than us to go out with a number of different directives to the team that are trying to deliver these services.
Thank you. I have no other questions. I'm grateful for your evidence, and I'm sorry that we've kept you a little late, but it's been important to hear from you, so thank you.
Thank you.
Chair, in the evidence of Mr Dove, I neglected to ask for his second witness statement to be adduced, so I'll just do that now. It's at CJS 0074042.
Thank you, indeed.
Thank you. Yes, 10 o'clock.
10 o'clock
tomorrow.
Thank you. Thank you, Mr Wells.
All rise.